Good afternoon, gentlemen. I'm joined today by Colin Lancaster, Chief Executive of the Scottish Legal Aid Board, and Stephen Carey, Senior Technical Officer of the Scottish Legal Aid Board. Thank you both so much for taking time to join me. Are you well?
Yeah, very well. Thanks, Ali. Thanks for having us.
Yes, indeed, Ali. Thank you.
Great. Thanks very much. Now, we are recording today to talk about a consultation that is being launched in relation to accounts assessment. Can you tell me why you are doing this and what you're hoping to achieve?
Yeah, I'll take that one. The work that we're doing here is part of a bigger project that we're involved in, and I suppose there's a wee bit of history which would take us back to the Legal Aid Review, which was conducted 2 or 3 years ago, and one of the conclusions of that was that the system should be simplified. We know it's complicated, solicitors know it's complicated, the public know it's complicated when they apply for legal aid. And sometimes that complexity can get in the way of the service being delivered or can slow things down or cause frustration. And the government has consulted on some of the conclusions from the Legal Aid Review, and they'll be considering how they take that forward. But in the meantime, we were keen to look at the things that are within our control, in the work that we do, in the discretion that we are given by the Act and the regulations. And we could see what we could change about how we do what we do, with a view to trying to simplify the process, make it clearer, make it more transparent, and really so that we can be held to account for the decisions that we take. So there's only so much that we can do because the regulations are very extensive. But one of the areas where we're given some discretion is in accounts assessment. And so we're looking closely now at all of our policies in relation to the assessment of accounts, with a view to being clear about what we do, why we do it, and how we do it, so that we can incorporate those policies, which will be clearly stated, into guidance for the profession, and also guidance for our own decision makers. And we'll be publishing all of that. So there'll be no secret guidance for our staff that's different to what's there for the profession. It's all there. Our aim is to be transparent so that everybody can see what we do, understand it in advance, and hopefully that will result in a smoother operation of the system, fewer toings and froings, less frustration all around, because I think that's better for everybody, both those who are delivering this service and the team at SLAB who are charged with assessing accounts. So the approach that we've taken has been consistent across a range of our different decision-making functions. A number of your viewers will be familiar with the work that we did a number of months ago now in relation to the interest of justice test, where we consulted on potentially changing how we apply that test in summary criminal cases in the Sheriff Court. And as a result of that work that we'd done in the consultation, we actually changed that approach back in March. And that's meant that we no longer need specific information to satisfy the criteria for a grant in those cases. So that's within an area that we can adjust the approach. We think that that will have simplified and reduced the burden on solicitors. So it's that kind of approach that we're taking to accounts assessment as well, where the first thing we do is we examine our policy, see whether it's clear, and then write it down. So that we can share it clearly with the profession to say, this is what the legislation says, this is what's contained in the regulations, this is the space that's left for us to apply discretion, and this is how we'll go about doing that. This is the policy we'll apply, these are the factors we'll consider, this is the information that we'll need to help us come to decisions first time. So the first step is to state that policy, and then to translate that policy into guidance for the profession and our decision makers. We've already started publishing some of these policy statements and guidance in relation to aspects of criminal applications. Those are on a separate website that you can find via the SLAB website. And that kind of sets out that relationship between the policy, the guidance for the profession, and the guidance for decision makers. And the aim is, as I say, to be clear, to be transparent, to remove some of the mystery around how we do what we do or why we ask for certain bits of information. But also along the way, as we're looking at these policies, we might spot something that we think, actually, maybe that's not how we should be doing it. Maybe times have moved on. Maybe there's been a change in the external environment, and there are things that we might want to reflect upon and maybe consider whether or not we can change the approach, whether we can, like we did with interest of justice, whether there's a way of us reconsidering how we are satisfied. And so we still perform our functions and do the job that we're here to do, but we can take advantage of the opportunity to simplify things. So in some aspects of accounts assessment, that's what we're doing, and Stephen will thankfully be able to tell you more about the detail of that. But that's the real gist of why we're doing it. It's to make the system move a little bit more smoothly and take out some of that frustration, some of that source of, to be honest, it's a source of tension between us and individual solicitors and the profession as a whole. And we want to just make the system work that little bit better. It'll enable us to train our staff more quickly, promote consistency in decision making, and then that just understanding of what it is we're asking for, why we need you to give us that bit of information, how we'll use it, and help maybe frame the expectations around the sorts of decisions we might come to. So that's the background to what we've been doing in terms of reviewing it. The consultation itself is obviously an important step in this process where we're writing down our policies. We're really keen to hear views from the profession or anybody else who's interested on both whether the way we're setting it out is clear, but also whether it makes sense. Whether it's clear what it is we're doing and how we're going about doing it, and also whether solicitors agree with the policy as it's expressed. And so we're interested in views, and that will help inform final decisions that we'll be taking and rolling it into the guidance that will then come onto the website in due course. I should also say that one of the things that we're wanting to do through the consultation is get some insight, particularly into the experience of people with protected characteristics. So, very mindful of our equality responsibilities and the way we apply our policies, or the policies that we have, the decisions that we take, can have an impact on the way solicitors then deliver their services to their clients. So we're really keen to hear about any experiences that solicitors or others can relay back to us to help inform our equalities impact assessment, because that's obviously a crucial part of the policy development process. So general views, equality specific views, and those are all the things that we're looking for from the consultation process.
Fantastic, sounds good, and I think everyone would be very keen to derive the benefits that you've outlined here, Colin. So thanks for doing that. I wonder if we could then move on to the specific details of the changes that are being proposed in the accounts assessment consultation. If we could get an outline of them, please, and the benefits that you see them having for solicitors, please.
4 changes, and they may, for those that are not familiar with the legal aid, appear fairly modest, but they're very, very important changes as far as I'm concerned. And I'm hopeful that the profession will welcome them as well. They're all positive changes. They all effectively, or certainly 3 of them, make the system more flexible and will effectively allow for a payment level that's not currently experienced by solicitors or advocates, as the case may be. So, and the first one is in relation to the mileage charge, Ali. Historically, mileage has been paid by SLAR at 40 pence per mile. Now, there's been you may be aware, although your viewers maybe are certainly will be aware for the legal professionals amongst you, that there's been a couple of fee increases in the last couple of years. And one of the most common themes that we actually receive inquiries on when there's been a fee increase is whether or not that has resulted in an increase in the mileage charge. The answer to that is no, it hasn't, because mileage isn't a fee, it's an outlay that's payable to solicitors. So one of the things that we've had the opportunity to do as part of this GALA process, as Colin mentions, talking about trying to iron out inconsistencies across the various aid types in the general system, as we've had a look at mileage. And what we're proposing under the consultation is to increase the mileage from 40 pence to 45 pence. And that's in line with the HMRC recommended allowance for mileage rates. One of the things that will impact on as well, it's not just applicable here to solicitors or advocates. Again, talking about our approach to GALA and identifying areas where actually some of our approaches could have been more consistent than they were. For example, historically, ordinary witnesses have never been paid 40 pence per mile. They've been historically paid out-of-pocket expenses or a lower mileage rate. And one of the things that we're looking to do through the consultation process is just have one simple, transparent mileage allowance, regardless of whether you're the solicitor or advocate providing the legal aid services or the witness in the case that's acting. It will be 45 pence per mile. So that's the first proposal that's being made. The second is in relation, again, to accommodation and subsistence. So where you have to stay overnight, for example. Again, looking at our guidance, it could have been more consistent. And one of the things that we're looking to do here now is make it, again, a universal rate to accommodation and subsistence for solicitors, advocates, or witnesses who have to stay overnight. So what we've done is we've looked at the only rate that is actually prescribed by statute. There is actually, although it's a fee, it's payable effectively. It's an outlay that's payable to advocates for accommodation and subsistence. And that's prescribed at the level of £108.15 for each overnight stay that's required. If you compare that, for example, Ali, to historically our guidance for solicitors or witnesses, that has varied anywhere between £80 per night or £100 per night. And again, what we want to do is make it a much simpler system to understand. So again, regardless of whether you're an advocate, a solicitor, or a witness, then what we are proposing under this consultation is that you are paid in line with the prescribed rate that we have for advocates, which is £108.15 per night. Now, that will generally be a cap that's placed on the accommodation and subsistence per night. There will be an exception, as Colin talks about earlier, about those with protected characteristics. So if, for example, there's an ordinary witness and a reasonable adjustment has to be made for those with a protected characteristics, what we will do is we will see whether that gives us the discretion to uplift that rate because of the circumstances that apply in the particular circumstances of the case. And that would be in a situation, for example, where the allowance or the reasonable adjustment can't be covered by other schemes, such as the Access to Work scheme. So the third issue, and this is I think this is probably, I mean, mileage will be extremely important because it affects so many people, but the next one's quite an important change, as I see it anyway, is that it's in relation to travel to local court. Now, one of the things that we're trying to do here is make, again, a very simple system. And travel to local court, believe it or not, you may think this is quite bizarre, but due in part to the regulations and due in part to historical taxation practices, different approaches by auditors of court, there's different practices that have evolved over the years in relation to travel to local court. So, for example, in the criminal fees regulations, we are actually prohibited from paying travel to a court where a solicitor has a place of business. So we simply cannot do anything about that. That's enshrined in statute. And even if we did want to alter that, we couldn't do that without a statutory change. So it would be for the Scottish Government to consider whether or no that would be appropriate change to make. But for civil and children's, for example, or under advice and assistance, but not criminal again, there's no similar equivalent. There's no historical bar to paying travel to local court. Now, we've had practices over the years where the auditor in Edinburgh, for example, or auditor in Edinburgh Sheriff Court and the auditor of the court session, has allowed travel to local court, both judicially and in legal aid cases. That doesn't seem to be an approach that's historically been adopted by local sheriff court auditors. But one of the things that we are proposing under this consultation is that in cases where the regulations allow us to allow travel to a local court, we will now pay that to a solicitor who has to travel for a court attendance. So they don't instruct an agency solicitor. They believe it's essential for their personal attendance to travel to that court. They will now be paid or entitled to make a claim where reasonable for travel to attend the court hearing. The fourth aspect isn't a massive change, in all honesty, because it's also very rarely engaged. It's in relation to interpreters and translators. Again, most of your viewers will probably be well aware of this, but there is no such thing as a prescribed rate for outlays under the legal aid scheme. It just doesn't exist. However, what we have done is we've worked with interpreters and translators for a number of years now and developed a framework that provides guideline rates for those that want to do and undertake legal aid work. The framework that we've developed is broadly in line with the scheme that the Scottish Government implement in relation to their services framework for interpreter and transcription services. So anything that involves spoken language interpreting services, document translation and transcription services for public bodies are governed by the Scottish Government framework. And that's what the SLAB framework has been generally based on. Now, 99%, maybe not quite as high as that, but the overwhelming majority of interpreters and translators in legal aid cases are quite content to do it under the recommended SLAB guideline rates that are published. However, from time to time, and it's normally in cases where it's a very unusual dialect or where there's a very, very rare or very few, number of interpreters available, that the interpreter will decline instructions to work at the proposed recommended guideline rates published by SLAB. So one of the things that we are wanting to do under the consultation is make available a letter of comfort scheme, effectively, a letter of comfort procedure, whereby rather than solicitors instructing an interpreter, then being restricted back to the recommended SLAB rates, and then the solicitor having to bear the loss on that potentially, what we're proposing is to say that in circumstances such as that, come to us, make the application out as to why you have been unable to instruct an interpreter at the recommended rates. And what we will do, where appropriate, is issue a letter of comfort to the solicitor and the interpreter that allows an enhanced rate to be paid. And that will hopefully provide the comfort to the solicitor that they are not going to be out of pocket at the end of the day. So that's the four changes. As I say, they may seem fairly modest, but they're actually all very important changes, I think. They're all positive changes from the profession point of view, or even if you're a witness, it's a very positive change for a witness as well. And one of the other things I wanted to just slightly touch upon, Ali, was in relation to what's covered in the consultation. It's not a change, but it explains our approach on the assessment of how we approach the reasonableness assess. Now, reasonableness underpins our entire assessment process. So what we are very interested in receiving is feedback on the current policy position, and there are examples provided in the consultation paper, particularly if what we are suggesting may impact on equalities or corporate parenting duties. So the views on how the policy works in practice will be particularly helpful because it will allow us to frame decision makers' guidance and external guidance. So our intention is to set out clear decision makers' guidance that will underpin the policy statements that are shared in the paper. To actually clearly set out how we approach the assessment of accounts.
That's brilliant, Stephen. Thank you. Thank you for that comprehensive outline as to what's being proposed. Again, all sounds positive. In relation to the consultation process itself, in what way will the profession's input be acted upon? I suppose the fundamental question is, why should solicitors take the time to engage and respond to this consultation?
Well, I think it's it's a good opportunity for the profession to be able to comment on how we do what we do. I mean, it's in some respects, this is a new venture for us, setting everything out in this way. So we're really keen to hear whether it's hitting the mark. It's there to help the profession, and if it's not seen as being helpful, if whether the structure or the language or the approach isn't found to be helpful, then we're really keen to hear, and we can have another look at how we do that. I should say that prior to going out to the general consultation, we have had a number of discussions with advocates, with a number of solicitors, with some law accountants and auditors of court, just to kind of have an initial run through the approach that we were taking. And that was the first time, if you like, been out of the building, because we've been working on this for a while. But it's really important that you get that external perspective, and particularly from a user point of view, because this is about trying to make the system more user focused, and it's only the users that can tell us whether we're getting that right. And that initial informal discussion that we've had has actually been really quite helpful in identifying things in the draft statements that either didn't quite resonate or weren't particularly clear. And so we were able to go and revisit them, and also in the consultation paper, maybe explain a little bit more about the process and what we are and are not doing at this stage. So that's already been hugely valuable. And as I say, it'd be good to get that wide range of views so that we can, whether it's going back to the drawing board, hopefully not, because I think, as Stephen says, what we've identified here are changes which we really do think are positive for the profession, and so hopefully will be welcomed. But if there's anything that requires fine tuning, then it's really important that we hear that. And we're also asking more general questions about what the profession would find useful in terms of guidance. So we're suggesting that they go and have a look at what we've already done on the criminal applications decision sets. And then, if they've got any comments on that, then we can then work that in as we go through from these policy statements through to the legal aid guidance for the profession, and then onward to the decision makers guidance for our own staff. So it's really an opportunity for solicitors to have their say, to input, to influence both what we do and how we set that out to make sure that it meets the profession's needs. And there's no point us going through all this process if what we end up with is a range of guidance that nobody understands, or if it isn't seen as helpful in them being able to operate the system more smoothly. Or really what we want to be able to do is for accounts to come in, for us to be able to assess them, and for that to result in things being paid as claimed on the basis that the accounts that are submitted are cognizant of the guidance as it exists, or where there are issues that we're able to identify them quickly and get them resolved. So I think that's in everybody's interest, and this is, as I say, first time we've done this sort of thing, and I'd be really keen to hear from the profession, how it's received, and whether it can be improved.
Great, Colin. Thanks. And Stephen, you've been very keen throughout this series to promote solicitor engagement. Is there anything you'd like to add in relation to that point, please?
No, really just to endorse Colin's views. And I think I said in the previous session with GALA that it may not always be the perception out there, but we genuinely want to work with the profession to make things better. We want to improve the system. We recognise that there's frustrations. We are equally frustrated with some of the things that we have to contend with. It's just sadly a reflection of the legislation that sometimes matters currently stand. But as I said before, any solicitor or advocate who has a problem, please pick up the phone and give us a chance. And we'll try our very best to work within the framework of the regulations to find an accommodation on the problem that they're experiencing.
Yeah. We also know that when we do engage with individual solicitors, if they have a difficulty, if they're unclear about something, sitting down with us in this kind of setting can help us explain things in a way that enables them to maybe do things a little bit differently, or for us to understand what it is that they're trying to say to us, and that can actually help reduce the amount of toing and froing in account. So we do quite a lot of that kind of work with firms at the moment, where we're particularly those who are new to legal aid, but also some established practitioners. And we know that if they've been having particular difficulties with aspects of the operation of the system, just talking it through and explaining how it works can often unlock what's been a problem for quite some time. And that can result in, as I say, more accounts being paid at the first time of asking. And that's really what we want to get to.
Yeah. Brilliant. Well, thank you both. Is there anything else you'd like to add before we wrap up? Anything you'd like to cover or tell our viewers before we finish?
I suppose really just to say the consultation is launching now. It'll run until the start of November. It'll be available through the website, and the profession should look out for further information. So as I say, it's there. Nobody has to answer all the questions if they don't want to, but anything they can offer us would be really helpful. So we'd really encourage people to participate.
Yeah, thanks. Well, we'll post all the links as well to the consultation and other resources as well. So in the hope that engagement is as high as it can be. So thank you both very much for your time. Thank you for updating all of our viewers in relation to the proposed consultation, and I look forward to seeing how all of that develops. Thank you both.
That's great. Thanks very much, Ali.
Thank you, Ali.